on today's docket, Earl versus the state of Florida. Counsel?
May it please the court, Christine Davis with Carlton Fields on behalf of the petitioner Jermaine Earl. The issue in this case is whether a defendant has the right to challenge an illegal sentence, even if the result is that the defendant will end up with an increased sentence. This question is easily answered by reference to the plain language of Rule 3.800A and well-settled law. First, every case that has decided this issue, including decisions from this court and the First District and the decision below, has held that the imposition of a mandatory minimum sentence is not discretionary and must be imposed, and that the failure to do so renders that sentence illegal. As this court held in McDonald, this is so even if the mandatory minimum sentence is less than the sentence that the defendant receives for other offenses. Here,
Counsel, let me ask you this. Isn't it part of the framework of our law that people go to court when they have suffered an injury or they are in some manner aggrieved to seek a remedy for the harm that they have suffered and to obtain relief from that harm? And I'm just struggling to understand how this. I don't know how you characterize this. Is this recreational litigation? I'm just trying to understand how this fits within that kind of generally understood framework of the law. People don't just go to court to pick at nits. They go because they have suffered an injury. And it seems here that you've articulated no theory under which this sentence has caused an injury to your client. So what am I missing about that?
Well, first I would say that the law is clear that a defendant has a right to a legal sentence. And so I would submit that an illegal sentence is adverse to the defendant. Also, under the First District's ruling, you're essentially taking away or you're essentially granting discretion to the trial court to refuse to impose a mandatory minimum sentence. So if the trial court for some reason decides...
I don't think that would be the case. We would be saying that in those circumstances, that's for the state. The state has suffered the injury in those circumstances, and the state would be the one to pursue that.
Well, I would respectfully submit that the defendant has a right to a legal final sentence, and without that legal final sentence, that is aggrieved, even though it would result in an increased sentence. Because under the First District's decision, if the trial court can decide not to impose a mandatory minimum, and the defendant has no right to seek relief of that, the state could come back at any time, a decade later, and correct that illegal sentence under Rule 300A. And so they're always at peril. And then you're contravening the legislature's explicit statutory scheme that these mandatory minimums always be imposed because the trial judge does not have discretion.
The peril here, it seems to be somewhat inconsequential in light of the fact that your client has a life sentence. And this is about a minimum mandatory 10-year sentence. Is that correct?
That's correct. This court held in McDonald that a mandatory minimum sentence is required to be imposed even if it is less than the offenses that the defendant will receive for his other crimes. So I think the law is clear that regardless of whether the sentence is less than and may not increase the sentence, it's nonetheless illegal, and he has a right to have that impacted. Also, the court in Dunbar made clear on the flip side that when a mandatory minimum is not imposed, it's an unconstitutional sentence, and there's no double jeopardy violation to increase a sentence because he has no expectation of finality in that sentence. So while it seems strange that a defendant would seek to have his sentence increased, he is adversely affected by an illegal sentence that a state can come back in and attempt to correct at any time under 3800A, or that a court could at any time. And so a defendant has the right to be subject to a legal final sentence.
Counsel, let's say the court understands your argument about the importance of vindicating the principle of a legal sentence. Let's just can we get from you some candor about the procedural implications of a correction of the sentence, and again, under the lights that it is illegal. We're assuming that postulate. A new sentence issues. What are the procedural implications for your client, and are those what's motivating this lawsuit?
The record isn't clear as to what the motivations are of these defendants who are filing these motions, other than to say that they are entitled to a legal sentence and that's what they're seeking. To answer your question directly, a new sentence would likely allow them to have collaterally attack their sentence again.
I'm just wondering why not just be upfront about that? If that's what you're seeking, I feel like you should be able to stand and say so, and then defend that argument about why that should be the remedy. Can I hear an argument about that?
Well, I don't have the record below. Doesn't say the record below. Earl did not make that argument, and he has not made that intention clear. But to the extent that is what happens, it's a function of a trial court committing error and not imposing a legal sentence. And so the remedy is for trial courts to impose mandatory minimum sentences, as they are unquestionably required to do, that they have no discretion otherwise. And if their error results in a defendant being able to again collaterally attack a sentence, then that's one repercussion that should be fixed by requiring trial judges to impose their non-discretionary obligation to impose a legal sentence.
Let me ask you this, because you mentioned earlier that he could be adversely affected by the fact that the state could come back anytime later and move to correct the sentence. How would he be? Your client was sentenced to life imprisonment as a prisoner really serial offender, which means he has to serve day for day of his life. So let's say the state comes back 10 years from now and for whatever reason decides to move the court to reinstate the 10-year mandatory minimum sentence. How is your client adversely affected by that?
Well, an illegal sentence is one that no judge under any set of circumstances can impose, which is what this sentence is. And he would be adversely affected by coming back 10 years from now and having to impose an additional sentence. In McDonald, this court recognized actually that even though it seems that imposing a lesser sentence than the life sentence may have no practical effect in most circumstances, there are some circumstances where that could happen. So for example, we have constitutional amendments all the time, or changes to the legislature sentencing scheme all the time. And the example given in McDonald is that if the PRR sentence is for some reason vacated in the future, maybe a statute is amended that says your life sentence, after a life sentence, you should be able to challenge that and, get out in less time. That PRR sentence could be vacated, and then he would still have to serve the mandatory minimum sentence. So you never know what's going to happen to the other sentence. You don't know what's going to happen in the future. And so he has a right to a final legal sentence that he knows is going to, he knows the terms and he knows what's going to happen and he knows what the parameters of it are, as opposed to being at risk of having the state or the court.
The idea that he doesn't know, that somehow this gives him something he doesn't know. I mean, you're asserting that the state could do it. So he knows, but the correctness of that we'll leave aside, but is asserting that could be done at any point by the state. And so I don't know what he gains by having it done now, as opposed to potentially be done later. I mean, this seems to be a very a very fanciful advantage for him to get that at this point as opposed to being exposed to the potential of it later. What am I missing about that?
Well, I think you have to go to the plain language of Rule 3800A, and that plain language allows a defendant to challenge a illegal sentence at any time, as well as the state. It doesn't limit the defendant's right to seek to correct his sentence only if he's adversely affected. There's no right in there, or there's no requirement in there that he be adversely affected. It says that he can seek to correct his sentence at any time, and that's exactly what he's doing. It's a right that he has.
But counsel,
under 3800A.
isn't it? And I think this sort of gets to the Chief Justice's question, though. The text of the rule talks about where the records demonstrate on their face an entitlement to that relief. And isn't it sort of just a background principle of law that in order to be, quote unquote, entitled to relief, that you actually have to benefit from the relief? I mean, why? I understand sort of it just seems like you're kind of ignoring, your argument ignores sort of the context in which we would read these words in terms of vindicating that, you're entitled to things that will make a difference for you, as opposed to coming in and having courts litigate cases that aren't going to have any practical consequence.
Well, I think you have to compare, in that instance, compare the plain language of 3800A versus 3800B. 3800B specifically says that the state can only appeal a sentencing error that is harmful to the defendant. That language is not in 300A. So what we're left with here is the plain and unambiguous language of a statute that allows him to seek to challenge and correct his illegal sentence. There's no bar under the current law that allows him to do this, even if it results in an increased sentence. And this court in Dunbar recognized that the failure to impose a mandatory minimum results in a illegal sentence, and that he should be resentenced even if it results in a harsher sentence. So the court's recognized, although not precisely in this scenario, it's recognized that an illegal sentence must be corrected. The defendant has the right to a legal sentence, and that the rule does not preclude otherwise. I don't know. I would submit that the rule couldn't be changed to require an adverse effect, which could be one remedy the court might consider, because again, you would then effectively be taking the discretion, or be handing the trial court discretion to refuse to impose a mandatory minimum sentence, which is exactly contrary to the legislature's sentencing scheme, which requires that a mandatory minimum sentence be imposed under every circumstance, even if it's a lesser sentence than what the defendant is going to receive for his other offenses. He has a right to that legal sentence. The state has attempted to categorize the errors in this case as unlawfully lenient or incomplete, and respectfully, those are not supported by the law. Every case that the state cites has nothing to do with the imposition of a mandatory non-discretionary sentence. Those cases dealt with where the trial court had some sort of discretion in imposing the sentence. So for example, in one case, the court imposed a downward departure sentence from the sentencing guidelines without providing written reasons. And the court held that's incomplete as opposed to illegal, because it is a sentence that the judge could have imposed had it provided the written reasons. The same is true for the other cases that the state cites as supposedly inconsistent or incomplete sentences. And none of those cases apply here. Here, it's undisputed that the trial court had no discretion but to impose a mandatory minimum sentence, and that he has a right to have that sentence corrected, and that the trial court should not be given the discretion, even through a back door, to refuse to impose a mandatory minimum sentence, or that the state has discretion to allow the defendant to serve less than a mandatory, or to not have a mandatory minimum sentence. So I understand the court's concern of recreational filings and and why would defendants be seeking to do this when it's only going to increase their sentence? But this law is clear from this court that they have a right to a final legal sentence, and nothing in the current law and nothing under the plain language of Rule 3800A limits that or requires that he be adversely affected. If the court has no other questions, I'll reserve the remaining of my time for rebuttal.
Counsel?
Mr. Chief Justice, Associate Justices, may it please the court. My name is Charlie Lee. I represent the state of Florida. The issue in this case is not whether Earl's sentence was illegal or not. The question is whether the circuit court's denial of his 3800 motion, which was purely academic, as Chief Justice Kennedy pointed out, recreational, and it was pointless. Does he have a right to appeal that pointless motion? And the answer should be no.
But counsel, to view it as purely academic, it seems like you get back though to the question of whether there's an entitlement to the, quote unquote legal sentence. I mean, it does seem like if the court erred by not giving that relief, that correcting the error wouldn't be academic any more than the underlying error would have been academic.
To answer your question, Justice Muniz, he has a right to a legal sentence, but not a perfect sentence. In this case, it's nothing more than a technicality because it doesn't change his sentence at all. He's serving PRR life sentences on both counts. So by that logic, though, would there be no error at the trial court level to deny this relief? No, there would be no error. Another reason is because his sentence is final. Earl's sentence is final. Rule 300A talks about the court's power to correct an illegal sentence. Rule 300B talks about how the state would go about doing that. It says for the state to correct an illegal sentence, it has to benefit the defendant. So the state is completely barred from ever changing Earl's sentence. The fact that Earl didn't get what he was supposed to get as far as a minimum mandatory sentence under the 1020 life statute, the state can't do anything about that after an appeal. Dunbar also talks about that, and Dunbar hints at the fact that the trial court doesn't have an unlimited power under 3.800A either. Dunbar talks about the trial court having the ability to change Dunbar's sentence and impose a minimum mandatory sentence up to the point that the state's time for appeal has run out. I've cited some other cases like Kiriazzi's where they talked about, and that's one of the incomplete sentence cases, they talked about the court's ability to change a defendant's sentence within the 60 days under Rule 3800C. But to say that the court 8 years down the road when Mr. Earl decided to file his motion would have any power to add to his sentence, that seems that it would raise that would raise double jeopardy issues that would not allow the court to do that. So as far as the state's concerned and the court's concerned, his sentence is final, it's legal, it's incomplete, it might not conform with every aspect of the law. But one of the points I'd like to make is none of the drafters of the 1020 life statute would be upset by Earl's sentence. He's serving a mandatory life sentence on both counts. The fact that a provision was not added to his sentence that
the problem, the concern I have with it, I mean, and it may not be much of a concern, but the third DCA and the fifth DCA concluded that for purposes of 3.800 sub A, this is an illegal sentence. I mean, and the 1020 life statute requires a mandatory minimum. Now, I don't get from the record how this happened. I think the judge that presided over the trial and did the initial sentencing, I guess he retired, and then a second judge came later. But how was it that this got by the prosecutor in the courtroom when the sentencing was handed down? I mean, typically prosecutors jump on this.
Right, Your Honor. It's not clear from the record. There's only one page of sentencing transcript, and then the written sentence. The written sentence, it was either omitted as a scrivener's error or just not put in there. There was a jury finding on the robbery that he had a weapon, so it should have. The prosecutor could have appealed this had they caught it. But it's not clear from the one page of sentencing. The judge just simply doesn't mention it as far as the robbery count.
But isn't there? Sorry.
No, go ahead.
Make a question. I mean, the rule of law basically is what we live under. And the law here is that the 10-20 life and that 10-20 life statute is a big deal. It was a big deal when it was enacted, putting requiring mandatory minimums with the use of a firearm. Isn't that a bigger question here? I mean, should just for the sake of consistency, just to maintain the rule of law that it requires it, therefore we should have it?
I agree. I think what Your Honor is getting at is whether there's one definition of a legal sentence and what an illegal sentence means under Rule 3800A, and it's not defined in the rule. And Carter talks about that. Carter's definition, this court's decision in State v. Carter, or Carter v. State, talks about a sentence, an illegal sentence being the kind of judgment no judge would inflict under the entire body of sentencing law, under any factual circumstances. In Carter, that was habitual felony offender sanction for a life felony where the statute didn't provide it. It didn't mention life felony. So there was no statutory authorization to impose the sentence as opposed to in Carter. That's not the case here. The statute called for more than what the court gave. Carter's the opposite. There was no statute to authorize the trial court's sentence. There's not a one-size-fits-all, and this is where my colleague and I think disagree the most. There's not a one-size-fits-all definition for illegal sentence in every circumstance across the entire body of criminal law.
But the state's position is that the sentence is not illegal, it's imperfect but legal. Is that the state's position?
It's not, Your Honor, it's not illegal for the purposes of Rule 3800A.
But it's illegal for other purposes? For what purposes is the sentence illegal?
It's unlawful. I mean, I cited a judge.
Unlawful but not legal? I mean, now you're losing me. Is the sentence legal or not legal from the state's perspective?
It's legal. It simply does not conform with the law.
Okay. So if we agree that it's legal but it doesn't conform with the law, then it would seem to me then the remaining question is whether or not the motion was proper. So why don't we go to the plain language of 3800B in the last sentence of it, right? Motions may be filed by the state under this subdivision only if the correction of the sentencing error would benefit the defendant or to correct a scrivener's error. How do you deal with the fact that the words by the state are in there and that the legislature could have excluded those words if it wanted to make this a bilateral provision?
Well, I'd agree with you, Your Honor. I'm sorry. I don't know why that was omitted. However, it doesn't make sense that a defendant would have more rights than, say, the court or the state to change his sentence 10 years down the road. I'm not sure why that was omitted, and I'm not sure why that. I don't interpret Rule 3800B to provide the defendants with that, the type of power that's given to them by Burke, Solomon, and Vargas, where they'd have unlimited ability at any time to challenge their sentence.
I don't read 3800B as giving a defendant any power. It's removing a power of the state, right? It says motions may be filed by the state only if something is true. No such restriction is applied by the statute to the defendant. I guess my question to you is, what do you take from that? Should we read in a new sentence that says, however, in the case of a defendant, this is not true? Is that what you're asking us to do?
No, Your Honor. I think when the rule was drafted, before the U.S. Supreme Court held that any resentencing can open up federal habeas, open up the time period for time-barred federal habeas petitions, it didn't consider that. It didn't consider the rule. I don't think ever considered that defendants would try to get a more severe sentence like Mr. Earl is. The only reason that they try to do this is to get to open up time-barred federal claims. And I don't think the rule, perhaps the rule could be changed to keep up with that, this trend. But I don't think that the rule was designed with that trend in mind. I think Mr. Earl's use of
this goes back to the same question I asked Ms. Davis. I wish the parties could just be candid about this. If that really is what's at stake here, let's just agree that this is going to give the defendant a fresh set of deadlines in actuality. How should that change the analysis of it all from the state's perspective?
It shouldn't change the analysis, Your Honor. That's speculative relief. It's collateral relief. Rule 3800, and I keep saying Mr. Earl misused Rule 3800, and he did it in a number of ways. Rule 3800 was designed to replace habeas corpus writs in Florida. And habeas corpus is designed to prevent defendants from serving an unlawful detention. And Mr. Earl is certainly not serving an unlawful detention. And just a moment, Your Honor. So the fact that I cited State v. The New York case, Francis. And Francis talks about, in that case, the defendant had a three-part plan and invalidating his sentence as part of that plan. And the same thing goes for Earl. But that being collateral relief, and Rule 3800, as I cited in my brief, is designed to attack the sentence itself, not the underlying conviction.
In the attack on the sentences in the 3800s, does the doctrine of harmless error ever come into play?
I think it might, Your Honor. In this case, it's not that Mr. Earl was negatively affected, or he wasn't affected at all. Mr. Earl's sentence won't change. Even if he's resentenced, his PRR life sentences will still change. So I think any error in the court's omission of the 1020 life sentence, well, as Justice Labarca pointed out, it's a serious omission that shouldn't have happened. But since it won't change his sentence, he shouldn't be entitled to be resentenced under 3800A.
Mr. Lee, could I ask a question?
Yes, Your Honor.
I'm interested in sort of the discussion of whether this is an illegal sentence in the special context of 3800A. And I think one of the problems with this case is that a legal sentence means something very different there than it means in other contexts. But in Carter and other cases, we say it's a sentence that no judge would give under any set of factual circumstances. And does the fact that a trial judge routinely gives and can give a sentence without a minimum mandatory if the state waives it, I mean, that would seem like a factual circumstance where a sentence could be imposed that did not include a minimum mandatory. It happens all the time.
I agree, Your Honor.
Why is this even an illegal sentence if it's one that could be imposed and is imposed regularly in courtrooms throughout the state of Florida?
I agree, Your Honor. In cases where the court fails to charge the jury correctly on 1020 life, it's not imposed. I mean, I've cited cases where the court hasn't imposed statutorily mandated sex offender probation. That's a statute that they have to follow, but they don't. And courts have found that that's not an illegal sentence. Mandatory restitution provisions, courts have found that that's not an illegal sentence. So not every time, there's many cases where the statutes have called for a certain sentence. That sentence has not been imposed, whether it's an omission by the court or an omission by the state, or maybe agreed upon by the parties. And it's not an illegal sentence that the defendant can challenge at any time.
But in instances in which trial judges and prosecutors agree not to impose and require a mandatory minimum sentence, typically that's as a result of a negotiated plea. And what typically happens in those cases is that the state comes in with an amended information that does not contain the language that requires a mandatory minimum. And typically that information is not filed until after the judge has accepted the plea and is over, and then the state files that. But that's the way that's usually done. I mean, the state doesn't file the defendant does not plead guilty to a charge that requires a mandatory minimum. That's how that happens. Now, what happened here, I think this is after trial in this case, in our case today. Am I correct?
That's correct. But to answer your question, Justice Labarga, when Carter talks about a sentence that cannot be imposed under any factual circumstances, a plea arrangement is one of those factual circumstances. There are factual circumstances, and the law does allow for these things. In a plea agreement where if Earl had entered a plea, yes, Your Honor, they would have filed an amended information. It would have been a legal fiction. It would have omitted facts that really happened to get Earl out of the punishment that he would deserve based on the crime he committed. That's a factual circumstance that the law allows for. And I think that makes Earl's sentence fall under Carter. It's something the court could have done under certain factual circumstances. Unfortunately, the circumstances didn't exist, but Carter was getting at, you can't impose a sentence that there's no statute for at all.
Yeah, but it would not be an illegal sentence if the defendant pled to a charge that does not contain the language requiring a mandatory minimum. It may be a legal fiction in this because he kept it out intentionally, but it would not be an illegal sentence. But if the charging document requires a mandatory minimum, isn't that an illegal sentence?
I'd argue no, not under the definition of Carter, because it's something that can't happen. The statutes, there are statutes and factual circumstances that provide for it, where in Carter there wasn't. I would like to make one point about appealability. Rule 9140 governing appealability talks about denial of relief, and I argued that Mr. Earl was not denied any relief. I supplemented the record. I didn't make this argument in my brief clearly, but I supplemented the record a couple weeks ago with section 924.051 Florida statutes. That is the statute governing limiting jurisdiction on criminal appeals. And while 9140 requires a denial of relief, 924051 requires a prejudicial error. And I'd ask this court to read those in peri materia, that coupled 9140's requirement for relief and the statute's requirement for prejudicial error shows that Earl was not entitled to appeal because he didn't suffer any prejudicial error. Unless the justices have any other questions, I would ask this court to affirm the decision, the first district's decision in Earl that finds that pointless, the circuit court's denial of a pointless motion to correct sentence is not appealable. Thank you.
Counsel?
There is not one case that we've found, and we've cited 7 or 8 cases in our briefs. Every single court, including this one, says that the failure to impose a mandatory minimum sentence is an illegal sentence. So I don't think we can question that the sentence in this case is illegal. Then you go to the plain language of Rule 3800A, which is the applicable rule under which he sought relief here. And that does not contain a harmless.
Are any of those 3800A cases?
Yes, they are. We have. I can file a supplemental authority on this, but there is the State versus Jimenez is a 3800A case. Gartrell is a 3800A case. Now, in Gartrell and Robinson, those were 3800A cases, but the court, they had different facts, and the court found that it wasn't illegal because the court had discretion to enter the sentence. But there are 300A cases where they, McDonald may have been one, where they acknowledge this is an illegal sentence. This is a sentence that has to be corrected. A trial judge has absolutely no discretion but to enter a mandatory minimum sentence, and the failure to enter that mandatory minimum sentence renders the sentence illegal.
But let me go back to a point raised by Justice Poston. Why isn't this, from the perspective of your client, a harmless error?
Well, 2 reasons. First, there's no law that I'm aware of that I have seen that allows a harmless error analysis to be applied to an illegal sentence. All of the cases that this court and others have held that there's an illegal sentence requires it to be resentenced. The next answer is that you don't know what's going to happen in the future. You don't know what will happen to his PRR sentence. Yeah, he has a life sentence right now, or 2 life sentences for a prison releasee reoffender, but you don't know what's going to happen in the future. Something could happen that could vacate that, and then you don't have this mandatory minimum in place. He has a right to a final legal sentence. And unless the law or the legislature wants to allow the trial court to have some discretion in deciding whether or not to impose a mandatory minimum sentence, which it does not have right now, then the sentence is illegal and it has to be corrected. Otherwise, you're giving the trial court, Justice Lawson mentioned that this happens all the time, that's giving the trial court discretion as to whether or not to impose a mandatory minimum sentence, and that is not allowed. The statute is very clear, and the cases construing the statute is clear.
But that's kind of conflating the issue of whether the judge made a mistake with whether it can be remedied by a defendant who's going to only be worse off if the sentence changes. I mean, just you keep talking about plain language, but the rule doesn't say that you can correct an illegal sentence and seek relief, even if the quote unquote relief would be adverse to you. I mean, are drafters of rules and statutes supposed to draft around absurd possibilities? I mean, are they supposed to assume that people are going to be seeking relief for things to make them worse off and have to preemptively say you can't do that?
Under our law, as it's currently written, under the case law, the statute, and the rules, there is nothing that says that an illegal sentence does not need to be corrected because it's harmless. There's nothing that says that. All of the cases say that an illegal sentence must be corrected. So unless the law changes, which would effectively give discretion to the trial court, and the legislature could change that, just like in the Francis case they cited.
But counsel, that's probably because in those cases they didn't seek something that would be adverse to them.
Well, then that may be a change in the law that has to happen in the future, but that's not how the law exists right now. But let me mention that in Dunbar, Allen, and Jimenez, Dunbar is a decision from this court, Allen is from the 5th DCA, and Jimenez is from the 3rd DCA. They recognize, opposing counsel mentioned double jeopardy. They explicitly hold that does not violate double jeopardy when a mandatory minimum sentence has not been imposed, the sentence is illegal, and the result is that he gets an increased sentence. That doesn't violate double jeopardy. That you have to impose a legal sentence. And so I submit that applying the plain language of the rule and the fact that there is no law that says that there can be harmless error for an illegal sentence requires that this sentence be vacated and that he be resentenced, and unless in some future instance the law changes. And so we would ask that you quash the decision under review and approve the decision in Burks, Vargas, and Solomon.
We thank you both for your arguments.
Thank you.
So we will now move on to the next case on our docket.